Good morning. Welcome to the Courtroom Files Live. One of the stated goals of this channel being to show different versions of court, different versions of the legal system, let you see more than just what you always see. This is a parole hearing out of the state of Louisiana. They are considering revoking this person's parole. So let's give this a listen.
Is Terrebonne Parish ready? Is there any staff at Terrebonne Parish in the room? Could you introduce yourself, please?
First Lieutenant Beth Bailey from Terrebonne.
Okay, thank you, thank you. And seated there in the orange jumpsuit, are you Mr. Derek Jones Sr.?
Yes, sir.
Could you tell me what your DLC number is?
429623.
Okay, that's right. So you get a check mark. You got that right. Okay, you're accused of violating some particular rules, and that's what we're here to talk to you about. Let's see, I believe Mr. Barra is handling your case. You're accused of violating rules 2, 3, 7, 9, and 10. And you're gonna get a chance to go over those and what your statement is, and if you're guilty or not. And we're gonna talk about it for just a little bit, and then we'll vote, and we'll let you know if your parole has been revoked or if you're gonna get out. So, Mr. Barra, are you ready to handle this?
Yeah. Did you have a parole revocation questionnaire that asked you about your lawyer?
Yeah.
You understand the nature of the proceeding?
Yes, sir.
Right. I'm looking through the case. It looks like you're not eligible for appointed counsel based on the Supreme Court guidelines. So we can proceed if you're ready.
Yes, sir.
Okay. It looks like the first violation you have is number 2, that you failed to submit monthly reports when you absconded supervision on or about 11/1/23. I'm asking you to plead guilty, not guilty, guilty with the statement. I'm gonna let you have your say after. I just need to know how you plead to each of these charges, and then you can give us explanations after.
Okay.
Did you submit monthly reports while you were absconded?
Well, not monthly because it was twice a year he had me down to.
Did you submit those?
Yes. Yes. Even after the he put the warrant out, I still was in contact with him on a basis, but it wasn't a monthly basis.
So you plead not guilty now for that?
Yeah.
All right, number 3, you failed to provide a valid address and you failed to apply to have your case transferred to another state.
Yeah, I didn't have the my parole transfer to Texas because the house that we was living in, it got messed up for the storm.
Just go ahead and say guilty, not guilty, or guilty with the statement, and we'll come back and let you explain.
Okay, guilty with a statement.
And number 7, promptly and truthfully answer all questions directed to you by your parole officer. You failed to provide a valid living address when you asked.
Not guilty.
Number 9, that you agreed to visits at your residence or place of employment by your parole officer at any time, and also agreed to searches of your person, property, residence, or vehicle when reasonable suspicion exists. And that I or have engaged in criminal conduct. You failed to provide a valid living address for them to do that.
Not guilty.
And that you currently $4,849 behind on your supervision prepayments.
Guilty.
All right. Go ahead and tell us what is your reasoning, your statements for these violations. Why did you leave? Why did you not report as probation officer wanted you to, why did he not know your address?
Okay, when I first I took a job in with a company out of Texas. I drive over the road trucking. So I've been going from state to state for the last 4 years. And I never had a problem with talking to him. We was doing video chat the whole time that we was doing COVID. So after that, he told me that what it was, I think in 2023 that I needed to come see him. I had leased the 18 wheeler so I could start my own business. But everything kind of went downhill from there because the company I leased the truck from, they couldn't provide the amount of loads that they said they was supposed to. It was supposed to be from $7,000 to $8,000 per week, but they was only coming up with $3,500 to $4,500 a week. So all it put with me having, I wasn't getting no check every week. Everything was going straight to the truck. So they kept telling me that things were gonna get better. So, a couple of months, it had picked up for a little while and, things started going good for a little while, but then everything started going back downhill because they couldn't provide the loads. So it put me with months not having a valid check, only $50 here, $75 here, maybe $200 here. And, I had, during the course of that time, I'm paying $1,800 a month plus another $1,400 for the truck, for the insurance on the truck. So I wasn't really making money off of the truck, but I had 3 years to pay for the truck. Like right now, I'm down to 1 year to pay for the truck to finish paying it off. So I just was having a bunch of problems with, trying to figure out if I should just let the truck go after I've been paying all this time on it, or continue to, try to pay it off. With the problem with me coming down, my girlfriend wrecks my car while I was over the road. So I didn't have transportation to get back and forth. And every time that I was able to manage to get a load down this way, it always ended up coming down here like toward the weekend or maybe late like Thursday or Friday. And I usually call my parole officer when I come down, just to see. But most of the time on the, like late Friday, he's not going to answer, or he'll get back in touch with me during the next week or whatever. But the whole time, even after he put the warrant out for me, I still was in contact with him on a regular, just to check in with him, just to let him know where I was.
So you, in your opinion, you were in contact with him by telephone, but his version of it is he would have wanted you to come in and see him and talk to him because you had been hanging out of state for too long. That was what he was telling you?
Yeah,
You
that was
out there too long. And you
Yeah,
couldn't come back because you didn't have the money and you were tied up in the business up there. And
yes.
he couldn't see you he says he couldn't make home contacts because you wasn't
Yeah.
home here in Louisiana. You were living in your truck.
Yes, the house got for Ida, the roof got blown off the house. So the landlord, he never came to fix anything. My family had been living in that house for over 60 years. It's a house in Berg, Louisiana, and they just never came fixed it. The house was owned by the Ellanders.
Mhm.
So they never got around to fixing the thing. So everybody, my family was my grandmother and my mom and everybody, they moved to Opelousas. And it was only, my uncle, he's a little mentally challenged, so they really didn't have room for me there. So I thought if, I stayed in the truck, to try to pay it off, that, everything would be situated once I get everything finished with that. But I never once tried to run or evade because I haven't been doing anything but working.
So fine. The reality is you have to report what the parole officer tells you.
Yeah, I understand that.
That's the problem. That's why you're sitting right there.
Yeah, I know.
What would be different if we would vote to let you have another chance today and go try it again, what would be different this time? Can you guarantee me that you'd find a way back to, and where are you gonna live? Can't live in your truck on the road.
Yeah, I know. I have an address in Karen Crow, Louisiana, that I can use, and
Live
I will
at,
go, I will go see I will be able to go see the probation officer, the parole officer every month, because I'm not gonna go back over the road.
okay.
I think that we have folks here to speak in favor and again. Okay.
Well, we'll go ahead and finish with you and then we'll deal with this. So your answer would be, you can find a place where you would be able to report.
Yeah, I already have somewhere where I can provide an address, and I will be able to start catching up on my fees.
And why do you, give us, the final question from me is, why do you think we should release you today?
Because I haven't been in any trouble. I wasn't evading. You know, I've been dealing with this since 2013, and I'm just kind of ready to get it over with. You know, I haven't done anything wrong. I try my best to stay away from home so I don't get in any trouble or don't fall back into anything that I was doing before. So that's why mainly I just kind of stay away from here. You know, I barely even come see my mama because of, you know, just not wanting to be around here like that. But I know that I should have transferred it somewhere else, but I didn't want to, you know, not have an address to provide for y'all. So, you know, that's why I kept everything in Louisiana where it was. But I've been driving from state to state for the last 4 years and kind of just living on the road, you know, trying not to have to, you know, depend on nobody else. Because my grandmother, she passed away on Christmas, and I didn't want to be a burden to nobody else. So, you know, I just kept everything like it was, just so I can, you know, I could try to, you know, have some type of business for, you know, for to leave my kids when I'm gone. You know, I started, you know, doing what I was doing to make a better life for myself.
Thank you. All right, I've been notified that we have a couple of people, victims, who want to speak at the hearing, so we're gonna open it up to them at this point.
Victims?
He's here for victims with family.
It's on the wrong.
Oh, okay, all right. Family members. Okay. Y'all signed the red card. Okay. Okay, we have a couple of people who want to speak on your behalf.
Okay.
So go ahead, Tina Edmonds.
My better is snorting up. Oh. Mr. Bowers here, there.
Either one, I think.
So I'm Mr. Jones' younger sister, and I live in Texas. And since he's been, you know, back and forth driving, you know, I can attest to him staying out of trouble. He spends a lot of time with my family, which is me, my husband, and my son. You know, he's a good dad. He speaks to his kids daily. He talks to everybody in the family as much as he can. So he's really a good, he contacts everybody as much as he can. You know, he comes over, we have Sunday dinners, whenever he's in town, and, you know, we just family, and I would appreciate if you guys would just consider, you know, either letting him come home or listening, you know, giving him a less amount of time to be there, just so he can get back to be with us. But, you know, I can say as far as it's every day, he tries to stay employed. You know, he's always looking toward the future to try to better himself. He's trying to go back to school. You know, and he just is who he say he is right now. He's completely changed. You know, and he's right about doing everything he can to stay out of Louisiana, to, you know, just not to get pulled back into anything, even by happenstance. You know, he was doing that so that he would get up here. You know, and I know that he should have been paying his fees, but I talked to his parole officer, and even he said that he kept in contact with him. He never lost contact with him, not once. So he was always available and able to be in contact. He just didn't go and visit him. So, I mean, that's what I'm asking. If you guys can just consider that he never ran, he was never unable to be found, and that he is, you know, staying on the right track.
All right,
Thank you.
thank you for coming. Miss Sylvia, right?
Oh, yes, sir.
I see you got a Karen Crow address. Is
Yes.
planning on living with you?
Yes, sir. Good morning. My name is Sylvia, and the address that they're in out is mine. I'm his girlfriend, and at certain points of time, I was there when he was working and when he was not working, mainly because of the job titles that he was getting. But I would love for him to get the favor of being that father that he wanted to be. But he can't because he's there, but my address is Karen Crow, Louisiana, and where I stay is like maybe a country town. The near Lafayette,
Would you give us your full address for the record?
400 Livingston Road, lot 28, Karen Crow, Louisiana, 705.
And how do you spell it?
Oh, Lord, that's,
I can't read your handwriting, but I definitely can't say the word.
if it's any way possible, I can go to my phone, I'll have all the proof. But I can't spell
You
Karen
can't
Crow.
spell it either?
No, sir, 'cause
It's not me. It's nothing for LOU.
LOUVE.
Oh,
TEA.
Yeah.
All right, that's close enough for
Okay.
today.
And me and my family we are relocating back to Louisiana as well. My husband is from Karen Crow, I'm from Lake Charles, so my husband's grandmother is about 15 minutes down the road, so we're gonna be there also, because I have a home in this house. So he'll still be around my family too.
All right. Okay, go ahead, finish.
Like I said, he can use my address to better himself, so he wouldn't have to go back to home, Louisiana, because I had to leave myself based on the hurricane, and I feel much better out there, and I'm pretty sure he would also too.
All right, he said use your address and you said use your address. When you're talking about probation and parole, it's live at your address.
Okay, well,
Live at your address. Using it is what people do who don't live there. They just use the address and say they live in there and put a couple of clothes in the closet and the probation officer can never find them.
Oh, no.
So I just want to straighten out the terminology. If he's gonna live with you, he's gonna stay there.
Yes,
He's
sir.
not just gonna use your address, he's gonna live with you.
I even asked his
Okay.
parole officer, Mr. Scott, and he also said, yes, he can use that address,
Live at your address.
Yes, sir.
Okay, thank you.
You're welcome.
Does anybody else have any questions for anybody?
I'm gonna look, do you have a truck now?
Yeah, I have an 18-wheeler, but I don't know if they're gonna let me keep it because I'm a couple of months behind on the payments. I'm almost 3 months behind. So I'm kind of hoping I can get out there and maybe catch up with the payments, you know, so I don't lose the truck. I've been paying on the truck for 2 years, and I just didn't want to give it up after all the money I spent on it.
Okay, well, I'm having a little bit of trouble here deciding because the parole officer went ahead and got a warrant for you back from May of 24, I think, because they hadn't heard from you in quite a while or something, and
No, it wasn't that he haven't heard from me. I was constantly in contact with him. He just kept telling me I needed to come down there to see him. So that was the biggest thing. It was me coming see him. It wasn't, you know, because when I was in the truck, I still video chatted with him and I still called him to check in with him.
That's correct.
okay,
Yeah, that's what Mr. Scott
Have you-
also told me, and I was.
let me, yes, ma'am.
Okay.
Have you ever been on parole before?
For who? For who? Before?
Yes, sir.
Yes, sir.
Did you ever get revoked on that parole?
Uh, I can't remember. It was back in, I think I was incarcerated from 2005 to 2007. Um, I can't remember, honestly.
Well, the reason I'm wondering, well, try to remember harder because I need to know. I mean, surely you can remember if you were out of jail on parole and they said you didn't violate it and did something wrong. And they put you back in jail. Surely you can remember that.
I think it had to be when I was right before I was getting off of parole, maybe in well, it couldn't have been 2007.
Well, it could have been. Could have been 2010.
2010. Oh, you're right. You're right. I had he made me do 30 days. He said I changed addresses without telling him.
Same deal. I mean, same kind of rule violation.
Yeah, it was the same deal. He said I changed addresses without telling him. I lived with I had moved in with a girl for a couple of months, I think. But I actually didn't notify him that I was staying over there. You're right. You're right.
You know, when you sign that deal, when you get out of jail, go on parole, that deal that you signed, that isn't a sheet of suggestions.
Yeah,
Okay.
I know,
You
sir.
understand that? Okay,
Yes, I do.
all right. That's all I got.
No questions. All right.
Fair to vote?
Yep, nobody has any questions. It's time to vote. I'm gonna go ahead and reinstate your parole with the condition that you report within 48 hours of your release to the Lafayette Probation and Parole Office. Be assigned an officer in Karen Crow to cover you there. That you pay the cost of extradition, which it costs to get you back over here, in the amount of $4,782, worked out on a monthly plan with the parole officer. That you follow all the other conditions of supervision and realize that you're not gonna get another break on this term if you don't report to the probation officer. Don't make your whereabouts known, and not just by telephone.
Okay.
Not on telephone probation, you're on actual supervision. You gotta see you. So good luck to you on that. I want to
Okay.
vote.
That's one vote. You need two votes. Okay? Mr. Tillis,
I concur with Mr. Barra.
okay? You got two votes. My vote would be to revoke you, okay? And I want you to know that because I want you to know how close you are to going back to jail for your full term because you're not paying attention to the rules you agreed to. Okay, we want you to be successful, and it does not take much to make it easy. These parole officers, they want you to succeed, and we're gonna give you another chance. Your parole or you're going to be returned to parole, okay? And you're gonna be released from jail because you got two votes. But we're serious about that.
Okay.
Okay? All right.
All right,
that's-
for the record, your excuses were all fine and dandy, but they didn't, I find you guilty of all the violations. Even
Okay.
with the excuses. They were good excuses, but they don't exonerate you from being guilty. You're
Yeah,
guilty
you-
with a good excuse. But
You won't have
so
you won't have more.
that ain't gonna help you the next round.
No,
All right.
it won't be the next round.
You just got lucky, and you got lucky because you had people who want to support you. You seem like you want to work and do the right thing. Okay, Get it
You're
through your
right.
head, you gotta be there. You gotta be there to be successful.
You're
All
right.
right.
Thank you,
Up
sir.
to-
Go conclude this hearing at 9:08.
Well, that's a nice way to start the morning, isn't it? Good morning once again. Welcome to the Courtroom Files Live. We've never looked at a parole violation or revocation hearing like that before. Those boards that oversee those things in the various states are independent from the courts. So, again, it's yet another look at something that we don't necessarily see all the time. So I hope you enjoyed that. And I hope this guy makes it work because he clearly has some people behind him and it seems like he wants to do the right thing. So hopefully this time things work out for him. Let's go ahead and go over to Judge Fleischer's court. It looks like things are a little quiet at the moment, but
Hey, good morning, Judge. May I approach? Angel Melendez on docket. And there were the issues with the PTI and the skip test. I've been speaking with him and I think if we can do a scram device, I think that'll work. He's working at Taco Bell. He's never had any positive test or anything. And his hours are kind of crazy. He'll work, night shifts and then typically 10-hour shifts.
Hold on a second. He's on PTI now.
Yes.
He has violations,
Yes.
right? Angel Melendez, come up. I don't know if it depends on how well he's been doing, what he's been doing, if he's done anything.
Yes, I know.
I'm not gonna just blindly reset someone if he's not done anything, Mr. Melendez, you were placed on the diversion program and you're here now because there are violations. What's going on, Shatori, with Mr. Melendez?
So they aren't asking for an extension, they're just making the court aware that he's averaging 1 to 15 skip tests each month. The probation officer has talked to him about it, and he's saying it's because he forgets due to his work schedule. He's currently enrolled in IOP, and he has to complete the DWI education and cleaning duties. And he's set to do that on March 26th.
Okay, I'll agree with you. We'll put the scram on him now.
I think that'll solve.
Failed to pay for it. If the battery goes dead, so will this case. I'm not going to entertain anything else. You have any more violations, that's it. Do you understand? You will be put to trial. Okay?
I was going to see if we could waive the court costs on this because he is providing for his family and I was appointed.
He's in the program. I can't pay for it.
Oh, it's the PTI.
If he's on bond for something, then I can pay for it, but he's in the PTI program. You're responsible for all the costs. Now you're going to foot a bill of $500 a month for this thing. Actions have consequences. And I'm telling you, if you fail to keep up with this device, the first instance, and I'd like to keep up, on a weekly basis, just to make sure you're out. That's it. Okay, Hugh.
Okay.
All right. So we'll send him today to get it. All right, Hugh. Thanks.
Shatori, can you scram the page? Sure. I don't print it out unless the place.
well, things are a little quieter in Judge Fleischer's court. Let's jump over to Judge Shackelford. We haven't visited with her in a few days.
On this form, there will be no trial of any kind. And you understand that if you're currently on probation or parole and you enter a plea of guilty, it could be a violation of your conditions.
Yes.
And you understand that if you're not a citizen of the United States and you enter a plea of guilty, it could have immigration consequences up to deportation. Knowing all that, sir, how do you plead the amended charge of allowing an unlicensed driver to drive?
Guilty.
Has anyone forced you to get you to plea?
No, ma'am.
Has anyone promised you anything other than the plea agreement to get you to plea?
No, ma'am.
Are you pleading guilty of your own free will?
Yes.
Mr. Gorman, were you operating a motor vehicle in the city of Taylor back on December 18th of 2024? And while you were operating that motor vehicle, was your license suspended, revoked, or denied?
Yes, it was.
And did you allow yourself to operate that vehicle?
Yes.
Satisfied, counsel?
I'm Judge, thank you.
Okay, I'm going to accept the plea as knowing and voluntarily given. Sir, you have a fine of 100, court costs of 100, crime victims' rights fee of 75, and a state assessment of 50. It brings your total to 325 on that. And then we also have the civil infraction. It's being reduced to a no point offense, right? A double parking, but double parking has a fine of 165. Do you understand that?
Yes, ma'am.
And do you want to the allegation on December 18th of 2024, you double parked in the city of Taylor? How do you plead, responsible or not responsible?
Responsible.
All right, I'll accept that plea. So your total is 490. And you can pay that all in 2 weeks?
Yes, ma'am.
Okay. All right, if anything comes up, Mr. Gorman, just let the court know, so you don't end up being show caused or get bench warrants, okay?
Okay.
Thank you.
All right, you're all set.
All right. Thank you.
Is it Siplakovic? Are we ready on, I have the city of Taylor versus, is it Sod Siplakovic?
Yes.
Okay. So today's the time and date set for pre-trial on this. Miss Manarino, can I get your appearance?
Angela Mandarin on behalf of the people.
And Mr. Siplakovic, can you tell me your first and last name?
Suad Siplakovic.
All right. And did you have any offers, counsel?
Yes, Your Honor. On the overweight violation, he pleads responsible. We could agree to fines and costs of $4,400. The remaining matters would be dismissed.
You understand that, sir?
Yes.
And do you want to take advantage of that plea?
Yes.
All right, to the allegation on January 21st of 2025, you violated city ordinance by having an overweight commercial vehicle in the city of Taylor with a stipulated fine of $4,400. How do you plead, responsible or not responsible?
Responsible.
All right, Mr. Siplakovic, I'll accept your plea with a fine of $4,400. Do you need time to pay that, sir?
Yes.
Can you pay it in 30 or do you need 60 days?
60.
60. All right, I'm giving you 60 days to pay in full. If you end up needing more time, just call the court, okay?
Okay.
We see a lot of that, excuse me, we see a lot of that out of the city of Taylor, both with Judge Shackelford and with Judge Slavin. There's a weigh station right there on I-75, and they're constantly popping these trucks. It's got to be a significant source of revenue for them. Let's go back to Judge Fleischer.
You know, there's sometimes there would be one thing if she was one of the this happened and then change it. But someone else saying that she was.
Yes, sure. Okay. You are Brianna Beck.
Yes.
Ms. Beck, you are now charged with theft. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
Judge, can I get the case number, please?
255-3536.
3536?
Ready?
Yes. On December 17th, 2024, an officer reviewed an OR, an offense report of a theft on September 17th, 2024. According to the report, the complainant reported that the defendant, known to the complainant by name and site, stole 2 espresso machines on August 9th, 2024. The complainant stated the defendant committed the theft at 3 other store locations. The officer reviewed documents that there were theft incidents at 4 home goods locations. The first incident occurred outside of Harris County, Texas. The second incident was investigated by the Harris County Precinct 4 Constable's Office. The third incident occurred on August 9th, 2024, where the defendant and an unidentified female entered the home goods and entered the line to make a merchandise return. Once in line, the defendant ran toward the back, where she selected 3 sets of sheets and then walked to the front of the store and rejoined the female in line. The defendant then placed the sheets on the counter and provided the cashier with her state ID. The system denied the non-receipted refund due to excessive returns without a receipt. The merchandise was then returned to the defendant. The defendant and the unidentified female then left the store, passing all points of sale without attempting to pay. The value was $599.99. The fourth incident occurred on August 9th, 2024. The defendant arrived alone at another home goods location and proceeded into the store with an empty shopping cart. The defendant selected 2 espresso machines and then walked to the front of the store and passed all points of sale without attempting to pay, and the security sensors went off. The value was $999.98. The officer reviewed the surveillance footage from the third and fourth incidents and compared them to the defendant's previous booking photo, and they were a match.
All of Marshall's Home Goods, is that what it is?
Yeah.
Okay, she's on bond for a theft. She's on bond for a gun case with us now. Where's the first theft?
The first theft is from a Walmart judge. $121.
Ms. Beck, I'm going to find that there's probable cause to go forward with the case, and I'm going to tell you now, I will do everything in my power to protect every person, place, thing in this county. And if I have to put you in custody and make your bond $50,000 because you continue to become a danger to our city, I will do it in a heartbeat. Do you understand me? I'm ordering you not to go to any Walmart, any Marshall's Home Goods, in anywhere. And I'm going to put a GPS monitor on you so I know where you are at all times. You are not to consume alcohol or illegal drugs. And I'm sending you now for a test so I know what, if anything, is in your system. You're to test and then you're to come right back. Do you understand?
Yes, sir.
Do you have a job at this time? What do you do for a living?
I'm a reservationist.
Okay, I want proof that you have a full-time job because that is now a condition of your bond as well. I want to make sure that you're working full-time as well.
And Your Honor, the defendant is also a complainant in this court as well. I need to bring up, we've reassigned these cases so that we can deal with it, and so it's on separate prosecutors. Like, I have the other defendant's case assigned to me, and Abigail is assigned this case. If that makes sense. She is listed as, so she is listed as the complainant in a separate case also in court 5.
In what regard?
So she.
Like in an assault or something like this of this nature?
Yes, it's an assault, Your Honor. And to.
Okay, so yeah, I mean, you divvy it up how you want.
Yes.
Because I don't want her to pick up 4th case.
Right.
No, we just want to
Sure
make
that-
you aware, Your Honor.
Yes.
I'm also ordering you not to be in possession of any weapons. Do you understand? These are your bond conditions. You violate these conditions, I'm going to revoke all of your bonds and I'm going to I don't understand why you're having attitude.
I don't.
You have now 3 cases. You're rolling your eyes as if you have some kind of. Need to talk about bond. What do you suggest as far as a bond in this case, on the newest theft case?
We would suggest a surety bond on the case, Judge, and leave it up to your discretion in terms of amount, but I don't think a PR bond would be appropriate here.
Well, if you do, make it a surety bond, we'd ask for it to be, low. She did show up here on her own volition today. And I think she's, at least for today, showing the right attitude about how to handle this from here on in.
Set your bond at $2,500. Cash or surety. No more PR bonds. Do you understand? I want to send her for a drug test right now. So Fleisha,
Judge, I can't send her until the bond has been posted, or else they'll take her into custody.
okay, then I'm going to give her a PR bond for now because I want to send her right now.
Yes, Judge. I'll still have to wait till that shop size.
Yep, go for it. Okay, I'm going to set the bond at $2,500. I'm going to give her a PR bond because I want to send her for a test now. You were to test and then you're to come back. Do you understand?
Yes, sir.
Not leave until you sign our bond conditions. Please take a seat.
Do I have to be back here when she returns?
No, I'm not. I want to know what, if anything, is in her system, but I want proof within a week of today of full-time employment. Okay, and then depending on what happens with the test, when we come back in a week, we'll talk about how to go further. Okay. Thanks.
Wow, I was just about to say that it's so rare for him to not give a PR bond, and then he turns around and gives one anyway so he can go get her drug tested. I hope she's not going to go career. This feels like something where somebody's going to go career and be a career criminal, because if you're stealing from these stores with their good security systems and you're just going to keep getting caught, I don't know. I don't get it, but you know, what do I know? Do me a favor if you would. We are very popular with the algorithm for our long form content. We're very popular with the algorithm for our short form. This live show is new. The biggest way you can help us out right now is go smash that like button. One simple button makes all the difference into teaching the algorithm that we are a news show and we deserve to be shown to others. So if you could do that, that'd be great. Let's get back to Judge.
Talking to Mr. Simondian.
I'm sorry, what was the last name?
Sertucci.
How do you spell that?
SER.
There it is.
My phone is off.
There it is.
So they're applying for PTI, but I just want to know if everything's in or not. Do you want to, hey, Vic, you want to give me a date for Sertucci while we wait?
How is April 22nd through the 24th?
Did you hear that?
April 22nd?
Through the 24th-ish.
Okay.
Whatever's best for
I
you.
can do the 23rd.
Okay, got it.
Okay. I just
Okay,
want to know
thank
if
you.
Discovery's complete real quick, see if everything's in.
Outstanding is station video, everything else is in.
Is it HPD?
It is.
That's a problem. All right, so if you can escalate and see what you can do so
Yes, I'll
we can
send
have
it
it by
to-
next time. Okay. All right, bud, we got you.
All right, thank you, Judge. Have a good
Take
day.
care. Okay.
Hi,
Bye.
Judge. Good morning.
You too.
Louis Juarez is on your docket today. It's unlawful carrying a weapon in a motor vehicle. And I had previously, he filed a motion to substitute.
Yeah, okay.
Everybody signed. I'd appreciate if you'd let me in.
Absolutely. Yeah,
Okay, and I'll get attached and I'll start working on it. Thank you.
I'm signing it now. Thanks.
Appreciate you.
Good to see you. Hi, Joe.
Hi, Judge.
What's up, man?
Sorry, Judge. Aiden Martinez is on the docket today, Judge.
And we submitted a mitigation packet. We just need a response from Chief Geis on that.
Is everything in?
He has not taken the TRAS, but he.
No, I know that. No. But as far as the mitigation packet,
They're still
Yes.
working on some of the root cause on this case. It's a multi-vehicle accident, so there's a couple of complaints that we are still trying to get in.
And I had
do
checked
you
with,
guys have insurance, hopefully?
I think so, but I had checked with her and I think you gave me the go ahead to submit the mitigation
No,
packet.
but I'm telling you, if it's multi and he didn't have insurance,
Right.
Yeah, so we're working on getting in touch, see if we can get those.
everything's submitted for the mitigation now?
Council, when was it submitted?
I
'Cause don't
submitted
have it
last
in the
night.
files.
Yeah, we have the NDA, the application, letter, everything.
So let's give it, I mean, it's old, let's give it maybe like a week and a half, 2 weeks.
All right, sounds
Okay.
good. And
All right,
I'll
Judge.
get those root calls done in time.
Thank you.
Yeah, okay, thanks.
No, but you that I can put it to.
Joe, if he's approved,
7 or 8?
Yes, sir.
he's got to be here to do the TRAS.
Yes, sir.
Right, denied, same thing, right? If it's still in limbo, then I'll wait.
Yes, sir. Thank you.
Yes.
Okay.
I think that was your only one, right?
Yeah, that's good. I'm sure that's why I try to do. But I know I'm in trial because the guy don't take it for you. We'll try it. That's the job. Probably got a big jack. Another one. Oh, this guy. You don't even want to know. I'm gonna get beat up for 2 weeks. Bang.
Bye, have a good day.
Thank you.
I have a there's an offer defendants.
I've currently got my eyes on 7 different courtrooms. Everybody's a little quiet at the moment, so we'll go ahead and run with Judge Fleischer. We did visit with Judge Shackelford briefly a little while ago, and she did a situation where it was an overweight truck. They have that weigh station right there on I-75 in the city. And I've been keeping a rough tally because that's pretty much all she's been dealing with this morning. And she's collected about $20,000 worth of fines so far for the city. So yeah, it's definitely a revenue source for them.
Just come right in the second floor. I'm gonna have you sign your bond, just so that I can process it. Judge, just to make you aware, I'm gonna have to pause the bond your condition, just so and then I'm gonna have to go to the JPC, and that's gonna take a while as well. And then once she's done JPC, then I can send it.
Okay.
I just wanted to give you a heads up, it's gonna be
Not a problem.
a little
I mean,
while.
it's still early.
Just because if I send her to 49 with an open warrant, I agree to do that. I'm gonna give you that. I'm just gonna have you sign her bond so they can get it processed.
Aiden, this way.
The fire. Just see for me, I'll click back. Just. Yes. Judge, could you please sign the bond in your queue? I do have a Do you have a number in the water? I can't. Oh, yeah, that's great. So one of the best stops. I also have. I mean, if you. I'm supposed to not wear. That, I don't think she's successful.
Yes,
Things are a little quiet everywhere except Judge Meineke's court. Let's cut there for a little bit.
For this driving event, alleged driving event, I'd ask the court to consider closing it because of the oversight 36, and because he certainly, as the court noted, still has to answer the court. Judge, I would note this, he does have 288 logged hours of community service.
Do you have those? Says that?
Your Honor, I did receive 80 hours recently. And then prior to that, I had 170 hours.
All right, so is he at least going to acknowledge that there was new police contact?
Judge Helen absolutely acknowledged it. He's already done it, so it's not.
Okay, please raise your right hand. Swear to tell the truth, the whole truth, and nothing but the truth, so help you God. Yes. All right, please retrain. All right, you have the absolute right to a probation violation hearing. At that hearing would have to be established by a preponderance of the evidence, not beyond a reasonable doubt, but by a preponderance of the evidence that you violated your probation. Only then would I proceed to sentencing. By pleading guilty, there's no hearing, we go right to sentencing. Do you understand that? Yes. Has anybody promised you or threatened you in any way? No. It's your own choice to do this? Yes. Is it true on March 10th that you had new police contact? Yes. All right. Satisfied?
Satisfied.
I too am satisfied. The plea is knowing, voluntary, and accurate. I'll accept the same. All right, so let's walk through this. So was placed on probation on February 15th of 2023. All right. And he had different periods of time of challenge, but he always rallied. He's been in compliance in a number of times. He took care of his responsibilities in Detroit. We just had that incident in December, which the court obviously had required him to continue to do testing, which all of his tests had prior to the scram tether has been on time and negative.
Correct. Any tests that he did miss, he did do his quarterly the same day.
And then the scram tether that he's been on now since March 7th has been no tamper, no positives.
Correct.
So since December 6th, we have no drinking events.
Correct.
All right, so that's good. He was ordered to do 40 hours of community service. He's done 288 hours.
Yes.
He goes to support group meetings. He's still attending his counseling.
Yes.
And the counselor, and I'm very proud of you for this, sir. The counselor said that you did admit the relapse to her during the session. I mean, that's the December relapse. That's a big deal. All right, because it tells me if you can't be honest with yourself, how can you be honest with anyone? And that's the one, I guess, the one area of real growth that I've seen is that you're more honest with yourself about your alcohol issue, about the different challenges in life, about how you need help. You're more honest about that than at any point in time that we've been together. And so this relapse prevention plan, there's a lot that's been accomplished here. I am certainly frustrated about the new charge. But I also recognize that what would my sanction be for that? Probably additional community service, which he's already done. He's gone above and beyond on that. And so, are you satisfied with the plea, by the way?
Absolutely.
All right, recommendation for today, Ms. Esdale?
Well, Your Honor, in light of the new charge, before the new charge had happened, I was actually going to recommend discharge. My recommendation has since changed because of the new charge, but I am inclined to agree with Mr. Yanga. I do believe that Carl's done a lot of work here. He is still being monitored by 36, so I would have no objection to discharging.
We're over the 2 years, and that's the other reality that I have to deal with, is that probationary period should especially misdemeanors, are supposed to be done in 2 years. So in order to extend this further, then the court would be going outside of what's allowable by law. So, Mr. Angot, what's your request for today?
To close, Judge, and frankly, based upon everything I've heard on the record here, I'd ask the court to consider closing with improvement. I know that's unusual because there's this kind of case. But, I think he'll resolve that favorably, Judge, and we'll be able to go forward. He's got to wait until October until he's eligible for an OHAO hearing. So he understands that, and again, just noting that the reason that he drove was not for fun, wasn't even just to go get a hamburger, it was to help a friend.
He's not supposed to be driving. Okay,
Right.
so that's the big challenge. I guess the only saving grace on that too is that he wasn't pulled over for bad driving. It was an expired plate. So anyway, sir, is there anything you'd like to say before this?
Correct, it was not expired plate, it was a brake light.
Oh, I'm sorry, Judge.
Okay. All right, is there anything you'd like to say before this court imposes a sentence?
Yes, since I've been on probation with you guys, I've actually been able to do things the proper way, like I'm supposed to, like you were saying, and it kind of helped me with ease alcohol out of my life for a lot of things, so I appreciate the help and the chances that you gave me to improve myself and make me better for my living.
Well, I will tell you, you're probably not out of the woods with Detroit with this new case. When they find out about the Oak Park case, make sure your probation officer there knows about it.
I just seen him under, he knows, and
Okay.
he looked at the system, it's not there either.
Okay. And you will need to make sure that as soon as you're eligible to apply for a license, one, you get all your documents together, make sure you have your relapse prevention plan, make sure you have a letter from your sponsor, from your counselor, everything to show that you're staying away from alcohol. Because if you're gonna be trusted back on the roadways again, they're gonna need to know that you are sober. And so whether I'm ordering you to be sober or not, this has to be a Carl Durrell choice every single day to stay away from alcohol. All right, it's taken enough from you. Liberty, money, dignity in so many different ways, but you've restored so much. So don't stop. Whether you're on probation or you're not, don't stop. It's your this court that the sanction is 40 hours of community service. I will give him credit for 40 hours of community service already completed. And the balance, he obviously owes a balance to the court, so go to a show cause docket, he can make payments over time, but he is discharged from this court.
Judge, if I may, regarding the balance, it was Carl's understanding at some point prior that the court would allow some relief of payment for community service work.
Well, we'll have to sit down with what he's done, what I've taken away for the sanction.
Yes.
All right, and then we'll put him on a payment plan, and then some of that payment plan could be met with some of the community service that he's done. So that's not off the table. All right, we just have to put together how much is due and owing, how much community service has been done, how much community service was just applied to the sanction, and we'll go from there. So we won't move forward on any specific payments until we get that all calculated, if that makes sense. All right. So he's discharged from probation with improvement. I do agree. From the time we started and the time he first walked in this room, he's clearly made substantial life improvements. All right. Good luck to you, sir.
Thank you.
Thank you, Your Honor.
Let's go visit with Judge Simpson for the first time today. He's working his criminal docket right now.
Will indicate defendant may travel to Tennessee on those dates inclusive. You're leaving on the 22nd. You'll be back you're traveling on the 25th.
Yes, sir.
Okay. So those dates inclusive.
Thank you.
All right. Thank you.
Sir, I know this is the risk of my own peril. Ms. Lonnie and I approached real briefly on a different matter.
Is there anything about basketball? Because if it is, I'm coming off the bench.
No, you're.
Okay, come on.
You'll notice I've not mentioned.
I know you are being very, very good, but I know what's going on in that head. And it's bothering me. All right. Yes, you may.
Thank you.
And just as soon as we cut to him, he mutes himself. Let's go check in with Judge Fleischer, who looks like he's at least woken back up.
Yeah. Okay, generate a voter forms and then Friday was 20. All right, got it. But I'm seeing what I know. Right at this moment. Is discovery from first stories.
Bear with the silence along with me for a few minutes. Literally every court I'm watching at the moment, and that is 8, are all either muted or they've got nothing going on, or yeah. So bear with us. Something will pop up here in a minute.
They require lawyers, defendants to consider offer and counsel to email. All right. Well, oh, that one, you're not going to do this for weeks. You have to approach for bond conditions. Okay. And he's here, he's. No, I'm saying.
Yeah.
Because he just stays in the house and stuff. And I feel like I should kind of do that today. Judge Courtney's old, right? And that's what you're doing.
Let's go see Judge Boyd for a second.
Good morning, Judge. Good morning. How are you doing?
Doing well. Can I approach real fast?
Yes.
We just wanted to hand this to you, invite you to our graduation. We have actually there's 2 letters in there for you.
Yeah.
2 graduates out of your court.
All right. And I'm opening this up without a letter opener. My mom would be very upset. Love the letters.
One of them is I was actually very proud of him how well he wrote it. It was very good for him.
It's April 23rd. I'm not gonna be here. I know, but I'm gonna write them a letter.
Absolutely.
The only reason why I'm not gonna be here is because my mom's birthday
nice.
is April 22nd. So I spend it with her. But I'm gonna. This is so awesome. I am definitely gonna write them both a letter back.
Absolutely.
But thank you all so much.
Of course.
No,
I'm good
otherwise
with
I
that.
would love to be there. If y'all are live streaming it, I will definitely watch.
I'll let you know for sure. I know we've talked about it, and if we
Mhm.
go ahead and get that set up, we'll definitely make sure that you have the link.
Okay,
Thank
awesome.
you,
Thank you.
Are you wanting my input on this? Is that why I'm here?
Let me see.
Okay.
Yes.
This way, they can turn on this side.
Yes,
Okay.
that's why.
I would probably need more information.
Okay.
What is his proposed, like, what is his proposed route?
All right. Well, I'll set it. Okay, I'll set it for a hearing.
Okay, I think Danny De La Garza was he's not really, because he sentenced him, but
Okay.
I guess that would just be my only.
Okay. All righty. I'll have them set it for hearing. All right. Thanks. Have a good one.
You too.
Warrants that are holding them up.
I was really hoping that Judge Boyd would have opened those letters that she was given, but that's okay. Let's go back to Judge Meineke.
Yeah, let's make sure that the record is clear on this. So there's a lot of different types of violations. We've heard today violations related to, use of substances or new criminal charges and things like that. This is a different type of violation. This is just we're running out of time. All right. So when someone's placed on a delayed sentence, you normally can keep that going just for a year. All right. And when we get close to the year, which is where we're at now, if you don't complete the terms, then we're not able to dismiss the case like we wanted to, and maybe even have to consider something like a jail sentence, which I have no interest in doing, Mr. Higgs. So we're here now to figure out, like, what are we going to do about this? Because we still have to do that class. We still want to do, this circumstance where we get you your license. Because I do not want, Mr. Higgs, for you, because I do not think you are a bad person or a dangerous person. I don't want you to have an interfering with police officer charge on your record. Okay? So, Mr. Engott, I know you likely to have had a productive discussion with Mr. Higgs. Can you give me an update on, like, how do we get this done? I desperately want to get this done for him.
He's in a much better spot now financially, Judge. He was in an accident that caused him to lose a lot of work, and then he's with Lear Seating, and work there has been very sporadic. In fact,
really,
it's been down to 12 hours a week, and he was laid off for weeks at a time as well over the holidays. So that's been the issue, but I think things are getting a little better at this point. It's purely financial. And after speaking with him, I think once he gets that settled, he'll be able to knock everything out.
So, Mr. Higgs, it still looks like to me that the only ticket suspending your license is the one out of warrant. You have other tickets, and we'll take care of those over time, but the only one that's actually suspending you is warrant, okay?
He contacted them, Judge. They want a $100 bond on the bench warrant. I didn't have time to look it up here because my phone is terrible here, but I don't know. A lot of time warrant, it looks on the driving records that it's a misdemeanor, and most of the time it's actually a civil infraction. He could kind of do the end around and pay online, but contacting the court, he's kind of convinced that they need their $100 before they address it. So he believes it's a misdemeanor.
All right, so but it's a no insurance ticket. A simple no insurance ticket. So you post $100, you go in and they'll give you a fine and cost, but once you pay that, then you should be able to get your license.
Yeah.
All right.
I think he's 4 years out too, Judge. So unless you tell us differently.
No, so because it's been longer than 4 years since you had your license, you have to take the written test and road test again. So you should tell them about the April 9th event.
Think of it, yes.
So can we print out that? Can we print out that brochure for the April 9th driving thing? So there's an event at the Metro Detroit Youth Club here in Royal Oak. It's at Campbell and Lincoln. And on that day, it'll be like there'll be almost like a Secretary of State branch opens up at the club there. There'll be information about, written tests, road tests. There'll be, United Way is going to be there for financial support options. So it'll be worth your time if you have a chance to make it on April 9th. They're partnering with us on this, and so we're trying to help people get their licenses. That could be a good helpful day for you. I'll have my secretary print out the information for you, okay? But in order to do this, to give them time to do this, I have to go beyond the year. And the only way I can do that is if we all agree to it. I'm okay with it. Is Mr. Higgs okay with it? Do you want to, if you still want to try to keep this off your record?
Yes,
Okay. So if I adjourn this 90 days, you're gonna make efforts to get this done?
yes. Only reason I haven't been able to do it because I had taxes to pay for my house that I wasn't aware of. I'm kind of a new homeowner, so it was stuff that I wasn't aware of, and I had to hurry up and pay that. And I didn't want to, lose my home and pay you guys. I'd rather, come to court and let you know what was going on.
Yeah, I would,
Pay you guys later.
I would definitely work with you on that. I don't want you to lose your home. So do you have a better line of communication with them now?
I do believe so. Like I said, this phone was turned off. Now I believe we have a better.
What about email? Do you have email?
I don't have an email because I lost my phone actually. So I lost the email, I lost the phone, I lost everything. But I have been in contact with them. I just missed probably about within that month because I had to talk. I talked to them like right before Valentine's Day. I was supposed to give them a call back, but I couldn't because I lost my phone.
That's true.
That was the only time that I missed.
So here's what, one, is your email a Gmail address?
It's an email. I mean, it's an iCloud.
iCloud? Okay. One, remember, if you're ever in a pinch, you don't have your phone, most local libraries will have a computer that you can use, so you can still access your email, so you still know what's going on. Just when you are done using it, log out completely, so
I
that
just gotta make a Gmail because it's so hard to get back to iCloud.
I agree. Get yourself a Gmail address. That's gonna be that much easier, and then you can access that. And that way, if you're ever up against it, you can just shoot us an email from one of the libraries, okay? But let's smoke this out 90 days, and we've given the information for the clinic. All right, hope to see you there. And, again, I will definitely take a look at his fines and costs here if he gets his license. All right, good luck to you.
Thank you.
Thank you. All right, who else is?
Let's jump back rather to Judge Simpson.
Good morning, this is Public Defender Lauren Perry on behalf of Mr. Cyrus. Mr. Cyrus, please state your name, character.
Thank you.
Here we have come to resolution. Mr. Cyrus is going to plead to an added count of retail fraud third. James Rivers misload count 1. Retail fraud the third degree is 93-day misdemeanor, $500 fine or trouble amount, contrary 750-3564. That is not your resolution of the agreement.
May I have him sworn?
You solemnly swear to affirm the testimony about the
Sir, it is the court's understanding you're going to plead guilty to the charge of retail fraud in the third degree. That is a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. The fine could be increased to 3 times the value of the property taken. If that's greater than $500, that would become the maximum fine. You understand that?
Yeah.
And still wish to plead guilty?
Yeah.
And to that charge, how do you plead? Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yeah.
All right, you signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights? Please look at paragraph 5 on that form. Those are your rights, which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right. Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No.
No? Okay. Nobody's promised you anything else, correct? Anybody threaten you or coerce you in any way to get you to plead? Okay.
Yeah, I'm on probation.
You are on probation. Oh, okay. And were you on probation as of the date of September 2023?
Yeah, I believe so.
All right. So the court does have to advise you that your entry of a plea in this case could be a violation of that probation. If it is considered a violation of that probation, that court could sentence you to the maximum allowable under that other charge. You understand that? And you still wish to plead guilty to this charge? All right. Has anybody threatened you or coerced you in any way to get you to plead? You're doing this voluntarily?
Yes.
Of your own free will?
Yes.
And because you believe that you're guilty of this offense?
Yes.
September 20th, 2023, at the location of 3825 Carpenter Road, that being the Meyer, what did you do on that date that makes you think that you're guilty? Some what?
Food.
Some food?
Yeah.
Okay, so you went into the store and tried to walk out with food without paying for it? All right, store was open to the public at the time? You didn't have anybody's permission to take that property, did you? And this food or other items that you took, this was property that was offered for sale by Meyer? Counsel, have I complied with the court rule? I knew it. What was the holdup? All right. Court will accept the defendant's plea to count two. Count one is dismissed.
Your Honor, I would ask for immediate sentencing. He has 98 days credit.
Has he, is there any restitution?
There probably is, Your Honor.
Okay.
I'm not, I double check. Sorry, I was thinking about a different case. Okay, there's about $540.
Yeah, okay. So we need a determination of restitution. So I'm going to refer the defendant to probation for a pre-sentence investigation and report. Sentencing will be
April 9th at 9 a.m.
April 9th, 2025, 9 a.m. or as his invite indicates. I'll set his bond at a personal recognizance since it's not. He's not going to need it. April 9th. All right. Thank you.
Thank you.
Court calls the case of the People versus Chiffon Hayes.
People. Good morning, Assistant Public Defender Lauren Kearney on behalf of Ms. Hayes. Ms. Hayes, please state your name for the record.
Stefan Hayes.
Thank you.
Your Honor, I'm asking for a brief adjournment. Ms. Hayes and I were unable to touch base prior to today.
April 2nd, 2025, 9 a.m. Her bond will continue.
I'll be in touch with Ms. Hayes, okay?
Did you hear that, Ms. Hayes?
Yes, sir.
All right, she'll be in touch with you. All right, thank you.
Thank you.
Court does call the case of the People versus Jacob Dorstein.
Good morning, Assistant Public Defender Lauren Kearney on Mr. Thorstein. Who
He's
is
not-
approaching, Your Honor.
I know. I don't think he's not in custody. This is a different.
Oh. Well, he was yesterday at like 11 a.m.
Mr. Dorstein?
Yeah.
All right, I'll pass that one. Let's bring him out. Court does call the case of the People versus John Fulton. That's who it is.
Veteran Solar on behalf of Pittsfield Township. Assistant Public Defender Natalie Paquin on behalf of Mr. Fulton, who is approaching the podium. Please state your name for the record, sir. John.
Thank you.
Thank you, Your Honor. I have discussed this matter with my client. She would like to accept the offer extended to resolve all of these matters by Mr. Siller, which my client would be entering a plea in the case ending in 0079 to add in count 2 of allowing an ineligible person to drive in the case ending 0240 would be dismissed.
That is correct, Your Honor.
May I have him sworn?
You solemnly swear to affirm the testimony you about to give me the truth.
All right, sir, it is this court's understanding that you're going to plead guilty to the charge of allowing an ineligible driver to operate a motor vehicle. Is that correct? Okay, that is a misdemeanor punishable by up to 90 days in jail, $100 fine plus court costs. Do you understand that? Still wish to plead guilty? To that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind. All right, you signed an advice of rights form today, is that correct? You signed an advice of rights form today, is that correct? Any question regarding any of these rights? Look at paragraph 5, you'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you're giving up those rights as well as all the rights on that form. You understand you're giving up your right to appeal of right. Are you on probation or parole? Has anybody promised you anything other than what's been stated here today to get you to plead? Anybody threaten you or coerce you? You're doing this voluntarily of your own free will. And because you believe that you're indeed guilty, on the date of January 10th, 2025, at the location of Ellsworth Road in Pittsfield Township, Washtenaw County, State of Michigan, did you have custody or control of a motor vehicle? All right. Did you allow someone who was otherwise ineligible, maybe yourself, to operate that motor vehicle? Yes? Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea to count 2. Count 1 is dismissed, as well as the case ending in 0240 is also dismissed. Anything you want to say before I impose that? How long has he been in?
Your Honor, he's been in custody since February 24th. He's not expected to be released in the very near future. He's being held on an armed robbery case that's still in the PCC stage. I would ask the court to consider sentencing him to state minimums as well as time served. Perfect suspended sentence.
So he's been in since when?
February 24th.
Sentencing cost of $125, 23 days, jail credit, 23, sir. Thank you.
Thank you, Your Honor.
Real quick, just to offer a little bit of an explanation as to what just happened there, because it's a legal oddity in Michigan, and we actually see this a lot in Judge Middleton's court in St. Joseph County in Michigan. But he pled to allowing another to operate a motor vehicle illegally, but the other is himself. It's a really bizarre thing that they use in the state as like a secondary charge to dismiss the larger charge. It's really weird because the person that you're allowing to do this is yourself. But they use it a lot. I don't know. Laws are weird sometimes. Let's get back to Judge.
Court calls case People versus Matthew Gibbons.
Senator, on behalf of the President.
Under Natalie Kate, on behalf of Mr. Gibbons, who is approaching. Please state your name for the record, sir. Your Honor, my client would like to ask for a 2-week adjournment of this matter. He is being held on other matters in circuit court. His next court date being 25th this month. So I would ask for this to be set on your next pretrial document.
Your name? Matthew Gibbons. Turn this matter out April 2nd, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Court does call the case People versus Ashton Ebler.
Assistant Public Defender Natalie Kate, with on behalf of Mr. Ebler, who is present via Zoom. Sir, can you please unmute and state your name for the board?
Ashton Ebler.
Okay.
Thank you, Your Honor. I'm requesting a very brief adjournment. I just got access to the discovery yesterday and was able to review it, but I still need to just have a discussion very briefly with Mr. Ebler about something.
April 2nd, 2025, 9 a.m.
Thank you.
All right. Thank you, sir.
All right. Thank you.
Court calls case People versus Joseph Pinkston.
Public Defender Natalie Kate, with on behalf of Mr. Simpson, who's approaching. Please state your name for the record, sir. So, Your Honor, there was an offer extended in this matter to which I have discussed with my client. To be candid, I was going to be requesting another adjournment to have another discussion with them about it. I'm still.
April 2nd, 2025, 9 a.m. Thank you. Court calls case People versus Trayvon G. Arraignment. G, no response. I'll issue an order to show cause for the defendant's failure. Garage Scott, I think. Oh. You're right, Barrage? Yeah. Okay.
This is public under Natalie Davis on behalf of Mr. Scott. Mr. Scott, please state your name before. Thank you, Your Honor. As Your Honor is aware, Mr. Scott is set for a competency hearing on one of his cases in front of Your Honor on May 15th. I'm respectfully requesting an adjournment of this case to sometime after that date, so that nothing happens in this case until that order of competency either way is found.
Oh, okay. What date will we have after May 15th?
May
21st. Okay, I'll adjourn this hearing till May 21st, 2025, 9 a.m. That was his grandmother. Okay. At 9 a.m. So I'll adjourn this out. Bond will continue. Mr. Scott's grandmother was here, and she was here, Raj. Yeah, no, she walked out, and then we called your case. So I had sent Mr. Allen out to find her, but she was outside. She went outside, but when she comes back in, we'll let her know. Okay, thank you. Wow. I mean, bless you. Korkow's case, People versus Kenneth Tennille.
Good morning. This is Public Defender Lauren bringing up behalf of Mr. Camille.
Good morning. What's your name? Thank you. All right.
Your the offer on this case is that Mr. Camille needs treatment. The cases will be dismissed. We are hoping to get Mr. Camille treatment. I believe he has a low cash bond in this case.
Yeah.
Maybe $2,000, 10%. I'd ask for a provision to be added that he may be released to treatment. He does have some pending cases in other courts, so there are a couple moving pieces that need to be completed before he's released, but I'm in communication with.
I will sign that. You need to prepare an order for both of these cases. I'll sign off.
Okay.
I don't have a problem with that.
And then we just asked for an adjournment out to allow that to take place if I know that.
I have the 2nd or the 23rd.
I think maybe the 23rd. Just
Okay, got it. April 23rd, 2025, 9 a.m.
Thank you.
All right. His bond will continue, but will be changed to incorporate that provision.
Thank you.
Thank you.
Let's cut over to Judge Fleischer. He finally has something to do, and he's managed to wake up to do it. So let's see what he's got going on.
So he's out on bond for an aggravated assault now, right?
Aggravated sexual as well. At Fort Bend, yeah, so he's on, he's got deferred adjudication out of Fort Bend County, Your Honor. And then he has these two new charges that he picked up. I thought you were saying in Harris County.
No, I'm just curious, what all does he have open at this time?
So it's just the Fort Bend County case, Your Honor, and I'm happy to apprise you of the facts and make sense.
No, I'm just, can you reprise what happened in this case, please?
Yes, so on February 24th, 2025, the officer was dispatched to a burglary of a residence in progress call in Harris County, Texas. The officer made contact with the complainant, the property manager, and the complainant stated that she was working around 11:30 a.m. and received a call from a witness who was working the pool and notified her that the defendant had kicked down the front door to a unit and the defendant had entered the unit. The complainant stated the defendant had been evicted from the apartment that morning and was given a reasonable amount of time to gather their stuff and leave. Once the complainant confirmed with the defendant that his stuff had been secured, the complainant locked the unit. Complainant stated the defendant still came back and kicked down the front door and entered inside to grab items. The damage was $650. The defendant stated that he was at the corner store near the apartment and that he was not in the unit, nor did he kick down the front door. The defendant stated that he was there to help with his cousin and did not do anything wrong. The officer observed a writ of possession taped to the door, stating on February 24th, 2025, the tenant was served and a trespass warning was attached to it. The defendant gave the law enforcement officer a false name, Latravius Bell, date of birth, March 26, 2000. Officer asked multiple times, to which the defendant confirmed his name was correct. And the defendant was later ID'd via APHIS to be Latravius Bell, revealing the defendant to have an outstanding out-of-county warrant out of Fort Bend for failure to appear for the aggravated assault with a deadly weapon.
Can I speak, Your Honor? My understanding of the facts, without saying this is what he said, but it was him and his cousin. The officers are responding to a description. His cousin also has dreads, Your Honor. They were moving out of the apartment that day. He took a break to go to the store to go get an iced tea. And his cousin found out that they had locked the door on him or whatever. And his cousin is the one who kicked the door in. But they both have dreads. He was coming back to the location. If you notice, he wasn't at the location when they detained him. He was coming back to the location. They stopped him and asked him his name. And because he had this out-of-county issue in Fort Bend County, he gave a different name because he wasn't sure why they were stopping him. But he wasn't there. He's totally caught off surprise with all of this. And it's of note that he was residing with his cousin and they'd just been evicted that morning. So they were moving their stuff out. So the conversation reads as if, or the DIMS reads as if it was all with him. It's not reading that it was with two different people.
Can you run the NCIC? My concern is that he has an open aggravated assault with deadly weapon. Is he on probation? Or is it just an open case?
He's on probation and it was an open warrant for failure to appear.
Which is why we're
You realize that you're on probation for an extremely serious case that could land you in prison for like 20 years. Do you realize this? No, I don't think you do. You can go to prison for a very long time. And it's a 3G offense, meaning that whatever you get sentenced to, you have to do half the time before you're even eligible for parole. So if they sentence you to 12 years, you have to do 6 until you're even eligible for parole. Do you understand? You must live like you have a freaking halo over your head because you've now picked up these 2 cases. Well, I don't even know if you're on probation, but if you are, and now you've picked up these 2 cases, Fort Bend isn't like Harris County. Brazoria isn't like Harris County. Brazos isn't like Harris County. They are a lot tough. Do you get my drift? What are you doing with yourself now?
I currently had a job. I lost a job when I went to jail, but I'm trying to get back to school.
People who have too much time on their hands become self-destructive. Mr. Bell, I don't want you smoking anything. I don't want you using alcohol, and I'm going to test you to make sure that you're not. Do you understand? And I want you back here in 2 weeks to show me what you are doing with your life, either a job or actively enrolled in school. And if you're not doing anything, it's really not going to go well for you. Those are probably conditions that are on your felony probation as it is. Do you understand? So I'm going to ensure that you're not going to fall through the cracks. Get my drift? So you either do it the right way or you're going to end up with me. I'm sending you now for a drug test.
Okay, got it.
I'm going to put a GPS monitor on you so I know where you are and you're not to go out in the middle of the night. Do you understand? And I want you back here in 2 weeks to show me what you have done. I want to see like 25 applications, or you must be actively enrolled in school. Do you understand? Okay, got it. Thanks, Doug.
Judge, 10.
Yeah.
After 6 or 7.
Do 10 to 6.
Refrain from.
Alcohol, drugs, no weapons.
Refrain from possession.
No going back to this location. Hey, Joseph, how are you, man?
Good morning, Judge. I'm here on Benny Hernandez.
Okay.
He should be in the courtroom, Judge. I don't know. He had texted me, but I don't know if we have an offer yet from the state. Don't have his file.
So there is an offer in the case, Joseph.
Yes.
We'll give you 2 weeks. Okay.
Okay.
The next setting, you guys got to come back and let us know what you want to do.
Okay. Thank you, Your Honor.
Yeah. Okay.
All right. Maybe excused.
You got it, bud. Hold
Thank
on.
you.
No. I need to get your date. Hold on.
Okay.
Help you first. It's not a big deal.
She's in custody.
Judge, what was that?
Bottom of 14. 2 weeks, plea or trial.
Your trial.
Yeah, 2 weeks. All evidence is in.
Else, April 8th through the 10th.
April 8th to the 10th, Joseph.
I'd like to do the 10th, Your Honor.
Required appearance?
Yes.
Okay.
Clear trial. Okay, man.
Hernandez?
All right. Thank you, Judge.
See ya. Hugh. You mean?
I set a plea for Cecilia Jackson, so time served.
Ready when you are.
It's Jackson.
Morning, Ms. Jackson.
Good morning.
And you're charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. You've worked out an agreement that they're offering you 3 days in jail with credit for the 2 days that you've done. You need to understand that this charge will go on your record. It's going to be there for the rest of your life. This now makes 2. What happens on the next one?
I think the jail time might be, it become a felony.
Prison time. That's what you're looking at the next time for a pack of gum. You could be looking at many years in prison. Do you understand?
Yes, sir. I do understand.
You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty, this will go on your record. You can never take it off. Not only that, from now on, you're looking at a minimum of 90 days in jail for any new cases that you pick up. Do you understand?
Yes, sir.
All right. How do you plead to the offense, ma'am?
Guilty.
I'm going to find you guilty. I'll send you to the 3 days in jail, give you credit for the 2. Please see the clerk. Thanks. Sure. Are you appointed on? Is he appointed?
Yes.
Yeah. Yeah.
Whichever name works one. Okay, got it.
Let's cut back over to Judge Simpson for a few minutes.
Ms. Tompkins, you'll need to turn on your camera and unmute.
Sorry.
Okay, there she is. Your name?
Ava Tompkins.
Thank you. All right, what are we doing?
Thank you, Your Honor. Ms. Tompkins is going to be entering a guilty plea under HIDA in this matter as charged.
Tompkins, can you raise your right hand?
Yes.
Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth so help you God?
Yes, Your Honor.
All right. State your name again for the record.
Ava Tompkins.
All right. Ma'am, it is this court's understanding that you are going to be pleading guilty to the charge of retail fraud in the 3rd degree. That's a misdemeanor, punishable by up to 93 days in jail, $500 fine plus court costs. The fine could be increased at 3 times the value of the property taken. If that's greater than $500, that would become the maximum fine. You understand that?
Yes, Your Honor.
All right. Still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, Your Honor.
Because of that, you're giving up certain rights. You're giving up your right to call witnesses to speak to you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand that?
Yes, Your Honor.
You understand you're giving up your right to appeal upright.
Yes.
All right. Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily and of your own free will?
Yes.
And because you believe that you are indeed guilty of this offense?
Yes.
July 9th, 2024, at the location of 2000 Waters Road, Pittsfield Township, Washington County, State of Michigan, what'd you do at the Target store that makes you think that you're guilty?
I attempted to leave with products that I didn't buy.
Okay, so you went into Target. Was Target open to the public at the time?
Yes, Your Honor.
All right. Did you have anybody's permission to take those items and to try to leave without paying for them?
No.
And these items that you took, these were items that Target had offered for sale?
Yes.
Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Court will accept the defendant's plea of guilty to this charge. Defendant is referred to probation for a pre-sentence investigation and report. sentencing in this matter will be April 30th, 2025, 12 p.m. noon, apparently. All right, Ms. Tompkins, thank you very much. Hold on the line. We're going to put you into a breakout room with probation intake so we can start the probation process, okay?
Okay, thank you.
Thank you.
Thank you, Your Honor.
Court calls case of the people versus Jason Williams.
Echelon for the people. Good morning, Mr. Supervisor, Senator Mark Perry, on behalf of Mr. Williams. Mr. Williams, please state your name for the record.
Jason Williams.
You got it. All right, what are we doing?
We are asking for a relatively longer adjournment. Mr. Williams is engaged in treatment. And Ms. Lobby would like to see him continue in that treatment before we resolve the case. So that's fine.
And that's right. The concern I expressed to Ms. Perry was that we had a lot of missed samples.
Yes.
For community corrections, and that she let me know that he's been testing with a different facility. But I suppose there's been some challenge getting those results to community corrections. So right now, it looks like there's no testing happening, which is very concerning given the charge. But I'm hoping that we're going to see it. So I actually was wondering if we could go like a slightly shorter adjournment, would be the April 2nd, so we can see the testing figured out, and then maybe like give them a chance to do better on bond to see if we can earn.
I'm glad you guys talked this thing through. I already wrote April 23rd. but
Okay,
what,
that's
the
great.
2nd?
23rd sounds great.
I'm just
That's all my concerns.
and I understand Ms. Lonnie's concern. I have been speaking with Mr. Williams about this like virtually almost every day. I do know that he's gone to test and notify multiple times. And he has spoken with Ms. Kerr about getting the results released. I know they spoke yesterday. I don't know if you have an additional update, Mr. Williams, but he is testing there.
April 23rd,
Thank you, Your Honor.
2025. Thank you. Court calls the cases of the people versus Robin Nobles.
Conrad Siller on behalf of Pittsfield Township.
And that's a lot of people.
All 4 cases.
Correct, Your Honor.
3. Last one's a 1.
This is probably kind of okay, but not on behalf of Snowballs in all 3 cases. May I please state your name for the record?
Robin Nobles.
Thank you.
In the Pittsfield Township case, it says 1200 1201. I'm moving to dismiss both of those cases.
Well, that makes that easy. Any objection to that?
No objection.
Okay, those cases are dismissed.
And there is an offer available for the state case.
Can I, just before you do that, just so that you understand she has a felony.
Felony? No, Your Honor. Yes.
You said felony, refused the word. I didn't know if I said it in French this time. Yes. That I want, I'm going to arraign her on now if you, unless maybe you want to speak to her before I do. Just get the charge. Nope. It's for possession of cocaine.
May I ask the offense date is, Your Honor?
Offense date of September 3rd, 2024.
I would be comfortable moving forward with the arraignment and addressing that. I've spoken with Ms. Noble several times. I did not know about this new case before, but I do understand.
All right, does that, in terms of any resolution on the other matter, does that change the people's perspective?
No, Your Honor.
Okay, so we're gonna do this one.
You arraignment, Your Honor?
Well, no, you had a resolution
Yes,
on
we
this
did.
case. So let's do that and then I'll arraign her.
And the resolution on the other case, Your Honor, is to plead with an account of retail fraud, 33 and 93 misdemeanor, $500 fine or a tribal amount, contrary to 750-356.
She's pleading no contest.
Correct, Your Honor. I did discuss that offer with my client and she would like to accept that offer today, pleading no contest as the basis being.
All right. Ms. Nobles, can you raise your right hand? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Your Honor.
State your name for the record.
Robin Nobles.
All right, you can put your hand down. It says court's understanding that you're no contest to the charge of retail fraud in the second degree. That's a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. The fine could be increased to 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. You understand that?
Yes, Your Honor.
Still wish, do you understand also what a no contest plea is? I guess I should ask you that.
No, I don't.
You don't. Okay, a no contest plea means that you're no longer contesting this charge of retail fraud in the second degree.
Okay, yes, Your Honor.
What? So is it account 2?
And attempt to retail fraud, third degree misdemeanor.
All right.
I don't know, fine. 7503560 equal.
So she's pleading to an add account 2.
Yes, sir. Yes, that's correct. Apologies for any confusion.
We're dismissing count 1.
That's exactly right.
All right. And it's a no contest plea. All right. So let me start again. Since court's understanding you're going to plead no contest to the charge of retail fraud in the third degree. That's a misdemeanor punishable by up to 93 days in jail, $500 fine plus court cost. The fine could be increased to 3 times the value of the property taken is greater than $500. That would become the maximum fine. You understand that?
Yes, Your Honor.
All right. With reference to a no contest plea, it, like I said, first of all, means that you're not further desirous or wanting to contest this charge. Do you understand that?
Yes, Your Honor.
You understand that the court that I would be and have reviewed the police report in the case, and I would accept the facts in that police report as true. You
Yes, Your
understand that?
Yes, Your Honor.
Okay. The other thing you need to understand about a no contest plea is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes, Your Honor.
All right. Any other questions you have about a no contest plea?
No, sir. No, Your Honor.
All right. Basis for the no contest plea?
Such a civil liability, Your Honor.
All right. So Ms. Nobles, to that charge of retail fraud third degree, how do you plead?
Guilty.
Or Ms. Nobles, do you plead guilty, not guilty, or no contest?
No contest, Your Honor.
All right. Thank you. Now you understand that by pleading no contest, you will not have a trial of any kind.
Yes, Your Honor.
All right. Because of that, you're giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand that?
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
I am not, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
and of your own free will.
Yes, Your Honor.
All right. Court has been provided and has reviewed Pittsfield Township Department of Public Safety report for their case number 245209. Any objection to the court having reviewed that report?
No, Your Honor. No, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Counsel, have I complied with the court?
Was satisfied? Yes, Your Honor.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Defendant in this matter is referred to probation for a pre-sentence investigation and report. Sentencing in this matter will be April 30th, 2025, 12 p.m. noon. Right? Ms. Nobles, I'm going to arraign you on your felony charge, but I'm going to ask you even after that to hold on the line so that we can put you into a breakout room with probation.
Yes, Your Honor.
All right. So,
Thank you.
yep, hold on one moment. Let's see what we have here. All right, court does call the case of the People versus Robin Nobles, the felony matter, and 125F 0284. All right, Ms. Nobles, you are before the court on a felony complaint that alleges that on or about September 30th, 2024, location of Washtenaw near Hawks in Pittsfield Township, Washtenaw County, state of Michigan, that you did possess a controlled substance, that being cocaine. Do you understand the nature of that charge, ma'am?
Yes, Your Honor.
All right. That's a felony punishable by up to 4 years incarceration, a $25,000 fine plus court costs. Do you understand that?
Yes, Your Honor.
All right. First question I have for you is, do you wish to be represented by an attorney?
Yes, Your Honor.
This is a public defender case.
Thank you, Your Honor. We would waive any further reading, standing, date, and also as to briefly address bond if appropriate.
All right. Defendant having waived formal reading, standing mute, court will enter a not guilty plea. I'll set a probable cause conference date of third. What's today? The 19th. It actually, I'm going to put it on the 27th. March 27th, 2025, 9 a.m. Yes, that's the bond.
Your Honor. So Ms. Nobles has been was recently successfully completed inpatient treatment at Bear River and has been in that program. And she's expecting as of Monday, I believe she will be moving to Grand Rapids for a sober living facility. That being said, she does live on the other side of the state. So I'm asking that any testing requirements that she not have to come to community corrections here for intake, that any requirements they have of testing at sober living, that be allowed to count as her testing.
So her sober living is going to be in Grand Rapids.
Yes. Is that correct, Ms. Nobles, right?
Yes.
Objection to that, Your Honor. We're not requesting any monetary component for bond.
Consider bonded at $5,000 personal recognizance bond, although the standard conditions, including no assaultive behavior or possession of any weapons. You understand that, ma'am?
Yes, Your Honor.
There's also to be no possession or consumption of any alcohol, recreational marijuana, or any illegal drug. You understand that?
Yes, Your Honor.
So here's how I'm going to do it. I'm going to indicate that the defendant is to test at community corrections. I do it, and I'll adjust it, counsel, depending on how often she's testing, but given the nature of the drug, I'd make that 2 times per week. But I will also indicate that the defendant may test in Grand Rapids, Michigan.
So, Your Honor, does she have to report to community corrections for intake?
She's going to have to call or somehow or another contact community corrections. Yes. All right. So I'll order testing 2 times per week. I will indicate on the order that defendant may test in Grand Rapids. And then I'll sign off on that order. Okay. Very good.
Thank you so much, Your Honor.
Thank you.
All right, let's cut back to Judge Fleischer's court.
You understand? Sir. You're giving up the right to a trial, right to compel witnesses testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty, you can never take this off or undo this. This is what you want to do. How do you plead to the offense of driver while intoxicated? I'm going to find you guilty. Follow the agreement. What do you do for a living, sir?
I'm actually disabled.
What's the nature of your disability?
I was with,
Okay.
What's the disability?
So
What's your disability?
My health issues. Agent.
What kind of income do you have coming in?
That, SSI.
You need to understand that DWI is big business. There's a $3,000 surcharge that would normally apply to this. I a lot of times waive it on first offenses because you know what? We all make mistakes. But I'm going to tell you now, if you continue to make mistakes where you endanger my city, a second DWI, it's a $6,000 surcharge. And you don't pay it, you do 1 day in jail for every $100 you owe. So on a $6,000 to $7,000, imagine how much jail time you'll do. Don't pick up another DWI because it's really not going to go well for you. You understand? All right. Good luck. Oh, I'm going to suspend your license for 90 days.
Judge, you had an ALR suspension for 3 months. It just got reinstated on the 16th. Is there any way we could get?
Let me see. Does he have any bond violation, anything like that?
No, there was no bond.
He's behaved good?
Edwards.
Edwards? No bond violations or anything?
No, Judge,
All right, I'll do it for you. Don't pick up another one. I'm telling you, 90-day minimum and a $6,500 surcharge. You understand? Okay, man. Good luck.
Thank you, Judge.
Thanks.
Wait, DPS, the red CC.
Yeah, let's go.
Okay, this one, you're asking else. Council.
So while things are a little quiet, a couple of interesting things. I monitor multiple courts, but I also monitor news as I'm going on. There is a lockdown right now at the CIA headquarters in Langley. Some armed man apparently nearby making threats. I'm not sure from the initial reporting if he's actually on the CIA campus or nearby, but that's interesting. And we started out our day today in Louisiana with that parole revocation hearing. And don't ever think that Google doesn't pay any attention to what you're looking at, because now all of a sudden my feed is filled with Louisiana legal news. And this came across that I found interesting. Last night, they executed a man by the last name of Hoffman, and it was the state's first execution using nitrogen hypoxia. There's a couple of states that have tried that now, so they're in on the action now too. Took 19 minutes, and the officials characterize it as flawless. So I don't know if he just fell asleep or what, but 19 minutes seems like a long time. As well, the facts around the case are really sad. I hadn't heard of this case before, but he was 46 when he was executed yesterday. But he was charged in 96, convicted rather, in 96 of kidnapping, rape, and murder of a 28-year-old person named Molly Elliott, which means Hoffman was, this was, 29 years ago, so he was 17 at tops when that happened. Obviously the waste of life of Miss Elliott, but that a person that's not even 18 yet would go out and commit such a heinous act is just, that always devastates me when I see that. It's such a waste of existence. I don't get it. Let's get back to Judge.
Yes. I was gonna reset it so I can look at everything. That's all.
I don't know about waiving it though.
No, that's fine.
How old is this case? You know, it's the case that we just had on Mr. Jones.
Okay.
The new theft is from February 11, 2025.
Than you? How many cases?
Sorry, I thought that he had multiple. No, that is from February 11th.
Mr. Jones, come up. I'll waive it. I thought it was old. It's not an old.
It's up to you.
case.
I don't care one way or the other. Whatever you want to do, Jeff. He wants to be here.
So, Mr. Jones,
Yes, Sean.
I've given you a lawyer.
I thank you.
So I usually waive people's appearances, meaning that you don't have to waste your time coming to court, but you have to stay in touch with him. If he tells me he can't get a hold of you because you're not answering his phone calls or text messages, I'm going to issue a warrant. All I'm asking you to do, don't get in trouble and stay in contact with him. That's literally all I'm asking you to do. Don't get in any trouble.
Yes, sir.
You understand?
Yes, sir.
All right, we're good. He can't leave yet because he has to sign bond conditions. As
Okay.
soon as he signs it, then we'll let you go. Okay, they're creating bond conditions. So you promise us that you're going to behave. We'll have you sign it, and then after that, you'll be free to
I'm
go.
not a better version, Your Honor. It's just looking at the damn paper. I changed my life.
I got you, man. We'll
Yeah.
trust you.
I've been
You're out and about with us now.
doing a lot for the community.
Just stay in contact with him, okay?
Give me my number once we're done, okay?
Can I tell you something though? I actually was on the news last year with Kim All, Judge Nimmy. They did a story on me in Channel 2 News. I was on the news. They used my story for the company I work for change for mental health.
That's great.
And I was on the story for Kim All and Judge Nimmy and Carnival. So I've made a bunch of changes. This is a mistake, and I just get so emotional when it comes to it. But I apologize.
Don't, because remember, they can use anything that you say.
I got you.
Just,
I got you. No problem.
Let me look at everything.
No problem.
We'll figure everything out, okay?
Thank you, Judge.
all right, so take a seat, but don't leave until we let you go.
All right, have a seat.
Thank you, Mr. Jones.
Okay, and then I got one more judge. This is, gonna be Vanessa Gonzalez. They're still trying to get a RIP call done, so, there's not a RIP done yet. So I'm just gonna reset that. It's 189 days old, that's why.
I mean, how long, we're now 3 months waiting for a RIP?
Right, and we've attempted to contact him multiple times.
People don't want to be found, or they want to be found. I'll give you a week. After that, just proceed as if without, Okay?
And she is here. Can I waive her appearance?
Yeah.
Thank you, Jeff. Have a seat.
So it looks like Judge Fleischer's court has gone quiet for the moment. The other courts that I'm monitoring, same situation. So we'll probably call it a day here in a moment. But the defendant that was just in front of him in the multicolored shirt, I actually saw him earlier in the day, but I didn't cut to him because we were in the middle of another hearing. I'll probably do a video on him later today because his behavior was super bizarre. So be on the lookout for that, which reminds me, if you're not subscribed to the channel, please consider doing so. We put out a lot of content, and we'd really like to have you as part of the community. Our community is actually very vibrant in the comments as well, so it's a fun place to be. This live show, though, is relatively new for us. We've only been doing it for a couple of weeks. The algorithm understands us from short form and long form. It's still trying to learn us when it comes to live show. So do me a favor, if you would be so kind. If you haven't already, please consider smashing that like button. That one simple button is the one thing that you can all do to help the show get found by the algorithm and then shown to others. Looks like everybody's quiet, so I'm going to go ahead and call it a day for now. Appreciate you joining us. We'll be back again tomorrow, 10 a.m. Eastern, 7 a.m. Pacific. Thank you so much. Take care. Have a great day, and God bless.